The first time I questioned a recording was when I heard the voice of the President of the United States saying something he never actually said. It sounded real. A few days later, I thought about Luca Modria e Jurors' testimony in the case involving Zdravko Mamiya, and how statements can shift over time. Theta Jurors when it hit me. We no longer live in a time where a recording ends the argument. When that automated call surfaced in early 2024, it did not sound artificial. It did not sound robotic. It sounded human. That is what unsettled me the most. The cadence was natural. The breathing felt real. There were small hesitations, slight pauses, even tonal shifts that suggested thought. It did not feel like a machine assembling words. It felt like a person choosing them. Later, investigators confirmed it had been generated using artificial intelligence. A synthetic voice model trained to replicate tone, rhythm, and vocal texture with disturbing precision. That confirmation forced me to revisit something basic. For decades, audio recordings carried serious weight in courtrooms. Wiretaps, phone calls, confessions, threats, agreements. When something was recorded, it felt anchored to reality. Legal systems built procedures around that belief. First, identify the source device. Where did the file originate? Was the recording hardware reliable? Was it properly secured? Then verify metadata. Timestamps, file structure, encoding patterns, transfer history. Then establish chain of custody. Who handled the file? When was it accessed? Was it ever duplicated? Was it ever exported? Those steps were designed to protect against editing, against tampering, against manipulation after the fact. But they assumed something deeper. They assumed the voice itself came from a real person at a specific moment in time. Artificial generation breaks that assumption. Because now the weak point is no longer the edit. It is the origin. A sentence can be created from nothing. A voice can be reconstructed from public material. A tone can be replicated. Emotion can be simulated. And the result can sound convincingly real to an untrained ear. That changes the evidentiary equation. The question used to be, was this file altered? Now the question becomes, was this event real? That is a heavier question. And it matters because courts rely on the stability of evidence. They rely on the idea that recorded material represents a fixed past moment. If that fixed moment can be synthetically generated, then authentication shifts from checking for edits to verifying existence. And verifying existence is harder. It requires expertise. It requires time. It requires technical literacy that jurors may not naturally have. Which means the courtroom begins to depend more heavily on experts. And when experts disagree, certainty becomes fragile. So this is not just a technological upgrade. It is a structural shift in how proof functions. Audio is no longer automatically persuasive. It must now defend itself. And that is a new reality. That is why the second example stayed with me. In 2018, Luca Modria gave a statement to investigators in a case involving Zdravko Mamiya. Later, during court proceedings, his testimony did not fully align with that earlier statement. I am not analyzing guilt. I am not revisiting the legal outcome. That is not the point. The point is perception. When statements shift, people react immediately. They compare transcripts. They replay interviews. They slow down footage. They analyze tone. They speculate about pressure. They debate motives. Even without artificial intelligence involved, trust becomes fragile when words change over time. A slight difference in phrasing can reshape public interpretation. A missing detail can trigger suspicion. A corrected statement can look like retreat. And that reaction happens before any judge speaks. It happens in headlines, in comment sections, in living rooms. Now add a new layer. Imagine a recorded testimony presented in court. Clear audio. Stable file. No visible edits. A confident voice delivering specific claims. Then imagine a defense attorney standing up and saying, "A question whether this recording is genuine. A. That sentence carries more weight today than it did 5 years ago. Not because manipulation is proven. Because manipulation is possible. That possibility alone can shift the atmosphere inside a courtroom. Jurors do not enter a trial as blank slates. They live in a world where synthetic media is discussed openly. They have seen examples online. They have heard about voice cloning. They know that technology can simulate realism. So when authenticity is questioned, the idea does not sound absurd. It sounds technically plausible. And plausibility is enough to open a door. The door is doubt. Not certainty that something is fake. Just the awareness that it could be. That awareness spreads quickly. If a human changes testimony, suspicion focuses on that person. We ask why they changed their words. We assume pressure, loyalty, fear, or strategy. If a recording is challenged, suspicion shifts outward. It moves toward investigators, toward systems, toward procedures, toward technology itself. The doubt becomes distributed. And distributed doubt is harder to contain. It does not attack one witness. It questions the reliability of the medium. That shift changes the emotional dynamic of a trial. Because when doubt attaches to a person, jurors evaluate credibility. When doubt attaches to technology, jurors evaluate reliability. And reliability feels more technical, more abstract, harder to resolve with intuition. So the debate moves from did he say this, to can we trust the system that claims he said this, That is a powerful reframing. It does not erase evidence, but it softens its impact. And in criminal law, softening impact can be enough. This is where the mechanics of criminal law become critical. Criminal law does not demand absolute certainty. It demands proof beyond reasonable doubt. That phrase sounds precise, but it is not mathematical. It is psychological. A juror does not calculate percentages. A juror evaluates plausibility. They ask themselves whether an alternative explanation feels reasonable enough to prevent conviction. That is where synthetic media enters the picture. If a juror believes there is a realistic chance that a recording could have been fabricated, that belief changes deliberation. Even if no evidence of fabrication is presented, the mere possibility can widen the margin of doubt. Deepfake technology does not need to overwhelm the courts to have impact. It only needs to be widely known. Once jurors are aware that voice cloning exists, denial strategies gain new credibility. In the past, denying a clear recording often appeared desperate. The audio would play, the voice would be recognizable, and rejection would seem irrational. Today, the same denial can sound technical rather than emotional. A defense team does not have to prove that a recording is fake. They may only need to suggest weaknesses in its origin. They may question how the file was obtained. They may question where it was stored. They may question whether it passed through systems capable of alteration. Each question may seem small. Together, they create uncertainty. And uncertainty is powerful in a criminal trial. Trials are not built solely on isolated facts. They are built on narrative cohesion. A recording often functions as a narrative anchor. It creates a decisive moment. It gives jurors something concrete to hold on to. If that anchor becomes unstable, the narrative weakens. That does not automatically lead to acquittal. But it changes how the story feels. Reasonable doubt does not require destruction of evidence. It requires erosion. A gradual softening of confidence. A subtle widening of alternative possibilities. There is also the issue of expert testimony. When authenticity is challenged, experts enter the courtroom. One may argue the file shows no detectable signs of manipulation. Another may argue that advanced generative models leave minimal traces. Jurors then face a technical dispute. They are asked to choose between competing scientific claims. But most jurors are not trained in signal processing. They rely on presentation, on clarity, on perceived neutrality. In that situation, credibility becomes performance. And performance can influence outcomes. So the introduction of believable fabrication does more than add a technical complication. It reshapes courtroom dynamics. It shifts attention from what was said to how we know it was said. That shift matters. Because once authenticity becomes contestable, every digital recording carries a shadow of uncertainty. Not because it is false, but because it could be. If authenticity challenges become routine, courts will have to adapt structurally. Digital forensics will no longer be a supporting detail. It will move to the center of the trial. The origin of a file will matter as much as its content. Metadata will be examined more aggressively. Storage systems will be audited. Transfer history will be scrutinized. Chain of custody will become a battleground rather than a checklist. That shift changes preparation on both sides. Prosecutors will need stronger digital documentation from the start of an investigation. They may require multiple verification steps before presenting any recording in court. They may rely on parallel evidence to reduce dependency on a single file. Defense teams will look for procedural gaps. Even small inconsistencies can be magnified. A delay in logging. An unclear timestamp. A device that was not immediately secured. Individually, these details may seem minor. Together, they create friction. Friction slows trials. Longer trials mean higher costs. More expert testimony. More technical explanation for jurors who may not have a background in digital systems. That introduces another complication. When two experts present opposing technical analyses, the jury must decide which explanation feels more credible. They are not just evaluating facts. They are evaluating competence, confidence, and clarity. Technology evolves faster than legal precedent. Detection systems improve. Generative systems improve. Each update narrows weaknesses in the previous generation. What is detectable today may not be detectable tomorrow. Law, however, moves deliberately. It values stability and consistency. It depends on precedent. That creates a gap between innovation speed and institutional response. During that gap, uncertainty grows. Not disorder, but inconsistency. Different courts may interpret digital authenticity challenges differently. Some may demand extensive forensic validation. Others may accept simpler verification standards. Inconsistency leads to appeals. Appeals create new precedent. Precedent eventually stabilizes the system, but that process takes time. Time is rarely neutral in criminal justice. Extended proceedings increase pressure on defendants. They increase costs for the state. They prolong public scrutiny. And there is also a resource dimension. Advanced forensic analysis is expensive. Not every jurisdiction has immediate access to cutting-edge detection tools. That creates uneven application of standards. In wealthier regions, evidence may undergo rigorous technical examination. In smaller jurisdictions, courts may rely more heavily on testimony from limited experts. That imbalance can affect outcomes. So this is not only about whether recordings can be trusted. It is about how institutions manage the burden of proving they can be trusted. When the medium itself becomes part of the dispute, the trial expands. The courtroom becomes a space not only for judging actions, but for judging technology. And that is a significant shift. What concerns me most is not a single fabricated recording. It is normalization. When skepticism becomes routine, even legitimate evidence must work harder to be believed. A recording no longer feels like closure. It feels like the beginning of another debate. There is also a strategic consequence. If believable fabrication exists, it creates space for denial. A person confronted with authentic audio can claim it is synthetic. That claim does not need immediate proof to influence perception. It only needs to sound technically possible. Some refer to this as the €s dividend. The existence of deepfakes gives real wrongdoers a defensive narrative. But the issue cuts both ways. Synthetic recordings can also be weaponized against innocent people. A fabricated confession could circulate publicly before forensic verification catches up. By the time experts disprove it, reputational damage may already be done. Speed favors manipulation. Verification takes time. This creates pressure on institutions to respond faster while remaining accurate. Prosecutors may respond by layering evidence. They may seek multiple independent sources to reduce reliance on a single recording. Defense teams may respond by questioning every digital step in the investigative process. That tension becomes part of the new equilibrium. I do not believe this leads to collapse. Legal systems adapt. They refine standards. They develop procedures. They incorporate technical expertise over time. But adaptation under uncertainty is uncomfortable. For decades, recordings felt decisive. They felt final. Now they feel conditional. Not meaningless. Not powerless. Conditional. And that word changes psychology. Because when certainty becomes conditional, doubt becomes more sophisticated. It does not shout. It lingers. So the real question is not whether courts can handle artificial intelligence. They can. The real question is how the awareness of synthetic possibility reshapes the threshold of belief. If tomorrow you hear a recorded confession, will you accept it as definitive? Or will you hesitate? And if hesitation becomes standard, how does justice redefine confidence? That is not a dramatic question. It is a structural one. And it may quietly shape verdicts long before we notice the shift.